Good afternoon to everyone. I'm Gerald Winslow. Welcome to our session today. I want to introduce Dr. Grace Wee in just a moment, but let me just say I am Gerald Winslow, the leader of our Ethics Center here at Loma Linda University. And we are scattered about in different places as we come to you today. Dr. Wee is in the Ethics Center library, and that gives me a good excuse to say that as soon as we open up for business again, we certainly want to welcome all of you to come visit us here on the third floor of the Centennial Complex. Right now, we are doing most of our work via Zoom and other distance media. So welcome to our session today. Dr. Grace Wee is a pediatric intensivist. She is also the director of our clinical ethics service for our hospital system here in Loma Linda. And she's the associate director of the Ethics Center here. Dr. Wee, thank you for hosting this session today, and I'm going to ask you now to introduce our speaker. You'll have to unmute yourself there.
Thank you very much. Welcome, everybody, and thank you for that introduction, Dr. Winslow. I am so delighted to introduce our speaker today, the Honorable Judge Tara Reilly. Judge Reilly is an alumnus of UCLA and Pepperdine School of Law. After law school, she entered private practice with Gresham, Varner, Savage, Nolan, and Tilden, where she developed a practice in civil, environmental, and business litigation. After 7 years in private practice, Judge Reilly was appointed to the bench in 1996 by then California Governor Pete Wilson. In California, after their appointment, Superior Court judges are re-elected for 6-year terms, and Judge Reilly has been re-elected multiple times, most recently in 2018. During her time as a judicial officer in the county of San Bernardino, Judge Reilly has served in every legal area, including criminal litigation, civil litigation, juvenile and family law, drug court, mental health court, veterans court, probate, conservatorships, and guardianships. She is currently the supervising judge for the probate department, which also covers conservatorships and guardianships. In addition to her duties on the bench, Judge Reilly also serves on the faculty of the Center for Judicial Education and Research, CJER. CJER is the educational arm of the state judicial system, and it provides training and education for judges and judicial officers. Judge Reilly lectures on judicial ethics and topics in the areas of family law and juvenile law. She also serves on a number of judicial committees focused on mental health and education. Judge Reilly is held in high esteem by her colleagues on the bench and the lawyers and clients who appear before her. She was given an award for Outstanding Drug Court Judge by Recovery Happens in 2007, the Access to Justice Award by the San Bernardino County Legal Aid Society in 2017, and the San Bernardino County Bar Association Kaufman-Campbell Award in 2012. The Kaufman-Campbell Award is awarded to judges who, quote, have demonstrated the highest standards of judicial excellence in the pursuit of justice while exemplifying courtesy, integrity, wisdom, and impartiality, unquote. Through her work on the bench and in judicial education, Judge Reilly has impacted our community in many ways. In 2008, she was named as a Speaking of Women's Health honoree at the Women's Health Conference sponsored by Loma Linda University Health. She continues to give back to our community in large ways and small. Judge Reilly, thank you so much for being here with us today. Thank you for your tireless work in pursuing justice, especially for the most vulnerable members of our society. Welcome to Loma Linda.
Good afternoon, Dr. Wee and Dr. Winslow. Thank you so much for this kind invitation. I am very excited to be talking about a topic that frankly is near and dear to my heart. I must confess to the attendants and participants, I am used to walking through an audience. I am used to seeing faces and calling on people in the audience when I present. So forgive me, this is a fascinating experience. What I would like to remind everybody is what we're going to talk about today. we're going to talk about the checks and balances between the medical field and the legal field, where we intersect, why my particular profession steps in now and again or has cases brought to us. We have a technical difficulty. We're trying to get to the slides. There we go. So, first slide. I'd like to talk to you about the 32,000-foot perspective, 32,000 feet, a place I haven't been since March of this year. But what we're going to be talking about and discussing today are the decisions that are made by third parties on behalf of unbefriended patients. And I want you to know that is not a term I made up. That is a technical term that describes the patients we will be discussing today. I know them in my work out at Ward B as incompetent individuals, people who have been determined to lack capacity. They're also referred to as residents, patients, and conservatees. So think about this. We're going to be talking about third parties, often you, sometimes me, making a decision about someone else's health care. What's going to happen to another human being? What procedure is going to be done? What medication they're going to be taking? Where they might be living? And although the patient or resident's interests are going to be protected, and there will be someone involved who is advocating for them, at the end of the day, the people in the situations that we're going to be discussing today are going to have decisions made for them. Oftentimes decisions that they are unaware of, and in many cases are not the least bit interested in having made on their behalf. Take a moment and think about the awesome power that that entails, that is vested in most of you, and that occasionally I look at and I review. It is a power that we have that comes with great responsibility and requires that when we're exercising that power that we never lose sight of the fact. This is another human being that is unable at the moment to speak for themselves, to assist in the decision-making process. And so let me go through the law a little bit, and then I'd like to hear your questions and answer any of your questions. And at the end, I'm also going to discuss with you my decision-making, how I look at certain cases, and what my thought process is before I sign an order that allows a surgery to move forward or psychotropic medication to be administered without the patient's consent. So, some rudimentary basics. Due process. This is one of the foundations of our legal system. I cannot hear a case until I have assured myself that the patient, the resident, the defendant, the respondent has already been given notice of the hearing and an opportunity to be heard. If there's no notice, there's no hearing. The notice must be in place, and remember this when we get later on talking about the Tanner case. Equal protection under the law. All right, this sounds like a very important, high-minded ideal, and it is. It is also one of the constitutional underpinnings of our legal system. And put very simply, equal protection under the law means that similarly situated persons should be treated under the law equally and enjoy the same rights and protections regardless of any other factor or characteristic. Now, due process and equal protection under the law. I'm moving through them in about a minute. I will tell you there is a year-long course in law school that focuses on both of these concepts and takes us deep into the weeds of what they really mean. But for our purposes today, I think it's important that you understand when I talk about checks and balances, I am going to be referring to the basic concepts of due process and equal protection under the law. I did a little bit of research on my own. I have not printed out the entire Hippocratic Oath, but I did pick up at least the basics. You also have a fundamental starting point for your responsibilities and obligations both to your practices and to your patients. And it starts with an agreement, a basic contract that you're going to educate each other, that you're going to assist physicians who are learning, that you're going to give them, those of us who are a tad bit more mature, you're going to help bring them along for the sake of the profession, not for your own personal well-being or for their own personal well-being, but for the sake of the overall profession. And of course, the words that most of us know. You are going to promise to work for the benefit of the patient and to do no harm. So let's start with those. Those are the underpinnings of our professions. There are 4 legal constructs that permit a third party to make a decision for another human being. Before we get into the weeds, I would like to talk about abbreviations. I don't know about your profession, but in mine, we have never met an acronym that we don't love. And you'll find out in a few moments, we've also never met a form that we can't improve and share with the world. These are some of the acronyms and abbreviations that I'll be referring to today. The first one, I pronounce it CANNER. Most of us in the legal side do. California Advocates for Nursing Home Reform. Another one we're going to really be focusing on is the IDT, the interdisciplinary team, and that's usually an interdisciplinary team meeting. Lanham and Petra's Short Act. For those of you who are not familiar with the Lanham and Petra Short Act, you'll hear it always referred to as LPS. It deals with our patients in psychiatric facilities and very carefully tells the judge how someone is going to become an LPS conservatee, and once an LPS conservatee, what they will be giving up and what powers the LPS conservator, often the public guardian, has. The last one is SNF. When I came into the probate department, I heard people over at Ward B talking about SNF. I finally grabbed someone and said, "What the heck are you talking about?" It sounded like someone had a cold. They laughed at me and explained, well, that means skilled nursing facilities. So we will also talk about SNFs when we get to the Canner case. I will perhaps come back to the screen if need be. All right, so I mentioned there are 4 primary legal constructs. And when I say legal constructs, I mean just that. It's legislation that has been created by our legislature. Some of it is also case law, but the case law in this area is more explanatory rather than making law. Probate law, the LPS Act, conservatorship law, they are statutorily based laws. When you have a question, you go to the statute, and the statutes, while they're not always clear, they will guide you as to what you need to be doing. And as I mentioned, we have a form for everything. So the first legal construct are powers of attorney, which also would include the advanced healthcare directives that you are probably very familiar with. The difference in this construct from the other 3, with powers of attorney, the conservatee, the person who is conserved, they have the power. They choose who is going to be the conservator. They choose who's going to be the holder of their power of attorney. The person who holds the power of attorney exercises the power to make healthcare decisions, oftentimes financial decisions, oftentimes housing or placement decisions. The person who is the holder of the power of attorney, they hold that power so long as the conservatee or the person who is giving the power of attorney allows them to hold the power. The person who gave the power of attorney, as long as they maintain capacity, has the right to revoke that power of attorney anytime he or she wishes to do so. The last thing I want to mention about powers of attorney. Powers of attorney will continue to exist even if a conservatorship is granted, unless, and this becomes important in many of our cases, unless the court vacates and suspends or completely revokes the power of attorney. Oftentimes, when a conservatorship is granted by the court, both in the probate court and in the LPS court, one of the first things that we will do is revoke powers of attorney, because we don't want the confusion of someone who holds a power of attorney making a decision and the person that the court has appointed to be the conservator. Generally, there will be some clashing, there will be conflicts of interest, so very frequently the court will revoke the power of attorney. At the top of this slide, you'll see the word represented patients. Every person who is brought into court and a petition of conservatorship has been filed, either in the probate court or in the LPS court, will have an attorney. More often than not, the attorney will be appointed by the court. That attorney's obligation is to represent the wishes of their client, the proposed conservatee. In situations where the client may not have the capacity to articulate their desires or their wishes, or simply the capacity to make any decision, the court will appoint a second attorney and make the second attorney a guardian ad litem. The guardian ad litem does not represent the patient or the respondent or the proposed conservatee's wishes. The guardian ad litem is charged by the court with gathering all the facts involved. So that means speaking to everyone, doctors, family, lawyers that have filed the petition, the attorney the court has appointed for the proposed conservatee. And then the guardian ad litem, and they are usually highly skilled attorneys who have been practicing for many, many years, they will then represent to the court what they believe after their investigation is in the proposed conservatee's best interests. The difference is the conservatee, the proposed conservatee's attorney, must represent the wishes of the proposed conservatee, even if the lawyer believes that the proposed conservatee's wishes are not in their best interest. It is the guardian ad litem that will say to the court, Your Honor, I know the proposed conservatee wants to go home, wants nothing to do with those psychotropic meds, but that would be an absolute disaster. Let me tell you why. So I want you to understand, in my world, we have so many checks before a decision gets made. We always make sure there is at least one person involved in the proceeding, protecting the rights and the interests of the proposed conservatee. As most of you know, conservatorship is, by definition, a court proceeding. The court is being asked to appoint a fiduciary, someone who will manage the care of another human being, who will provide food, clothing, shelter, who will perhaps also be overseeing medical, and in many circumstances will also be handling their financial interests as well. And you can imagine that's where we get into some real difficulties. Probate Code sections 2351 and 2352 actually give you the definition of a conservator. Conservators in medical decisions. So, a lot of people think, great, I've become the conservator of my child or of my spouse. let me start making these decisions. We start with the fundamental presumption that all of us are presumed to have the capacity to make our own medical decisions. The only time that that presumption is rebutted is by a court order after the judge has received, in probate conservatorships, it's called a medical capacity declaration. In the LPS Ward B world, it is also a medical capacity declaration, but it is an entirely different type of capacity declaration. I cannot receive information from a next-door neighbor, from a well-intentioned relative, or from a loving colleague to convince me that someone lacks capacity. I have to start with a medical opinion. And it comes to me in the form of the medical capacity declaration. At trial, it will come to me in the form of testimony by the physicians who know the proposed conservatee best, or by medical experts that have been retained by one side or the other. Once I have the medical information, I then hear from family members and friends and colleagues who can round out the whole picture of the proposed conservatee, what their observations are, what behavioral changes they may have noticed. That must occur before I can make the finding that the conservatee or proposed conservatee lacks the capacity to give informed consent or to understand healthcare decisions. 4 exceptions to the general rule that we all retain the capacity to make our own medical decisions. The first is obvious. It's an emergent situation. Frankly, emergent situations, the court's pretty much going to allow anyone who has a halfway decent understanding and interest in the patient to make the decision. The other 3 are going to require court orders. Conservators, once they've been appointed, do not necessarily have granted to them automatically general medical powers. You have to actually ask for those, and there's a very particular section of the medical capacity declaration that I have to have filled out by a treating physician before I can even contemplate giving general medical powers. Oftentimes, a conservator will come in and say, I don't want general medical powers, but there's one surgery that we need to have done. I'll take a look at the surgery, I'll take a look at the limited medical capacity declaration, and grant, more often than not, a single transaction order. You have the court's authority, essentially, to make medical decisions for one type of procedure or surgery. I will tell you, in 5 years in the probate court, I've never made that order. I usually make the orders you see in number 3. Most petitions that come in ask me for the general medical powers. There is an exception with general medical powers that does not include dementia powers. If you want dementia powers, you need to ask me separately for those. That requires more medical information before I will grant dementia powers. In the LPS realm, in Ward B, if you will, general medical powers in the LPS court come with the ability for the conservator to require that the conservatee take psychotropic medications. That sounds so lovely and so easy and so nice. Let me translate that for you. More often than not in the LPS court, when I'm granting general medical powers, I am giving the conservator the right to force psychotropic medications. If any of you have worked in a psychiatric facility, you know that the forcing of psychotropic medications on a third party who does not wish to have those psychotropic medications injected into them is an awesome responsibility for those of us that hold it, because those are very powerful medications that come with significant side effects. And the forcing of those medications requires oftentimes that a human being be physically restrained, that they are introduced to a needle, as they often tell me when they see me in court after I've made this decision, they really are not happy that I allowed that needle to be shoved into their bottoms. The fourth exception to the general rule that we all retain capacity. There are times when a conservatee, usually these are voluntary conservatorships, which are rare, but a conservatee wants to have a conservator even though they do still retain capacity to make medical decisions. But they don't want, for whatever reason, to have that responsibility. They give that to a conservator. There are times that gets confusing for medical providers. Confusion, frankly, I completely understand because I don't think this is a particularly well-drafted code section. And the conservatee will retain a lawyer for the sole purpose of giving informed consent to the physician. Go ahead, make the decisions for me. Now, I know some physicians, quite a few. Some of you might even be watching. And I suspect you think I would love to have that power. I would love to make all of my patients' decisions until you get that power. And then all of a sudden, that power becomes very real. And many people do not wish to be the only person making the medical decisions. In that instance, people will come to court and they will give the court a petition. They'll ask the court to review it, and then they'll ask the court to decide. Reviewing all of the information, Your Honor, would you like the physician that the conservatee has chosen to make those decisions? If all of the medical information is there and the conservatee has the capacity to make that choice, the court's decision is very easy. That is an easy grant and one that we're very grateful for. All right, let's talk about Probate Code Section 3200. Now, this is a code section that you are most familiar with in dealing with courts. I see probably 7 or 8 3200 petitions, as they're known in court, a week. I have never seen a 3200 petition in the probate court. I always see the 3200 petitions when I am sitting out at the LPS courtroom, which is in the locked psychiatric facility at ARMC. 3,200 petitions generally assume, and my general assumption is, that the patient is both unrepresented and unbefriended. The first time I saw that word unbefriended, I was stopped in my tracks. That is just one of the saddest, coldest words I'd ever seen. And it means exactly what it says, that the patient and the person about whom I am to make a medical decision has no friends, no family, no other human being known to the medical personnel, discovered by the lawyers, or known to the court to step up and say, I'll help make the decision, I'll care for this person. These are people that are in beds in every hospital in our county and fill many beds of our locked psychiatric facilities. And just as a point of interest, we have 7 locked psychiatric facilities in the county of San Bernardino. I digress for a moment. I have a huge problem with this because Los Angeles County has, I think, 4 or 5. Riverside County has 1. Orange County, the way they ship people to our county, it suggests to me they must have none. We have in our county patients being sent to us in our locked psychiatric facilities from San Diego, Orange County, Riverside County, Los Angeles County. I have had people put in ambulances and driven to our locked psychiatric facility over in Colton from as far away as Modesto. For those of you that are interested in this topic, get a hold of me later on. I have some very strong opinions about this particular practice. But it plays into this concept. You're an unbefriended person. You are in a locked psychiatric facility in a county in which you may have no other contact. And all of a sudden, you need medical care. You came into the emergency room. You were wandering the streets barefoot, had severe burns on your feet and possibly your body if it's been within the summertime. The emergency room doctors do exactly what they need to do. They provide you care, and in the course of doing that, they discover, not surprisingly, you have some very serious health problems. They need perhaps to perform testing on you, testing that's going to be a little more invasive than drawing blood. Or there is a need for you to have surgery, pretty emergent surgery, but not so emergent that there isn't time to get another opinion. You have a patient who perhaps, and very likely, lacks the capacity to talk to you, to discuss with you their medical history, or to make a decision about their treatment. You may have a patient that refuses absolutely to communicate with you. They won't even so much as give you their name. But you've got to make a medical decision. This Probate Code Section 3200 petition is your friend. The petition may be filed to determine that a patient lacks the capacity to make a healthcare decision. That's the first decision the court needs to tackle. You're asking for a specified treatment to occur for an existing or a continuing condition. And this is the key part of this. You're also asking for an order authorizing a designated person to make the healthcare decision for the patient. People frequently ask me, what's it like to have to make all those medical decisions? And I, quite frankly, am delighted to inform them I make no medical decisions. I'm not a doctor. I don't have your expertise, your training, and oftentimes I don't have your courage to make the kinds of decisions that need to be made. I am simply designating someone else to make that healthcare decision. Most of the 3,200 petitions that I see, I am designating the public guardian for the county of San Bernardino. Very occasionally, I am designating a family member who, without the designation, is unwilling to make any decisions. And very frequently, I'm designating physicians to make these decisions. All right. This is one of those forms I told you that we can't live without. This is the ex parte petition for court authorization for medical treatment. It is a template. If you read this while I'm talking, you're going to recognize the fill in the blanks. When you get over to page 2, at the top it says the declaration of Jane Doe, MD, which is attached, contains the following information. And all of the criteria is laid out. I will tell you that all of that information is required by the statute. You are literally looking at the code section 3201B that tells you what needs to be in the petition. You don't need to guess. If you have a patient and you can't get cooperation from the patient, if you are convinced the patient absolutely lacks capacity or refuses to communicate with you and assist you, this is the petition you need to file. This format is from the Public Guardian's Office. They are happy to share this format. It tracks the code exactly and tells the court exactly what the medical condition is, why the medical condition exists. This is a petition that was filed for a patient about 3 weeks ago by the state hospitals. We have redacted all of the basic information, but we've left in some of the medical information. I wanted you to see the kinds of information that comes to the court. This is the last page of the petition, which tells me what you're asking for. Now, this is, sorry, got all choked up. This is the declaration I look at first. Because frankly, I want to know what the doctor's saying. The lawyers will whisper in my ear. The lawyer for the hospital will whisper in my ear, tell me all sorts of things. The lawyer for the patient, excuse me, dry air. The lawyer for the patient will be whispering in the other ear. I want to know, what's the doctor got to say? The doctor is the one that's going to tell me, based on my experience, my training, my education, my profession, this patient needs this procedure or this medication. Here's why. Here are the consequences, judge, that will occur if they don't get this treatment. Here are what the alternatives are. Here's everything you need to know. When I look at the doctor's declarations, I will tell you, I look at these declarations with the thought and the belief that the information I am being provided is truthful, is accurate, and is medically sound. I do not start thinking to myself, well, what about this procedure? What about that procedure? Again, I'm not a doctor. I don't have your education or your experience. If I get a 3200 petition from a physician and I have questions, we call the physician. I put you on the speakerphone in open court. The lawyers are present. A court reporter is taking down everything you tell me. I will swear you in so that it's under oath, and your name will go in the minutes for that day. Again, this is a huge check and balance for the patient. I'm in open court. It is a matter of public record. I am asking for your advice and your explanation. Oftentimes, to be perfectly honest, you've used a term, I have no idea what it means. And I really need to understand if I'm going to be making an informed and intelligent decision. But that is the declaration that you would send me with the petition. This is the order. So all this work, the petition, the doctor's declaration, and you're looking at a one-page order. That is what I will date and sign if I approve the petition. 3,200 petitions, from my perspective, guarantee that our incapacitated, unbefriended citizens, members of our community, that they will have many people involved in making the decision over their medical care. There will be no one person to make that decision. And I'll talk a little bit about the decision making in a few moments. Skilled nursing facilities. These two concepts, skilled nursing facilities and intermediate care facilities, are going to become important in our next conversation. I'm about to start talking about 1418.8 and the Canner decision. The citation to the Canner decision is at the bottom of this slide. In my world and in my profession, We live by citations. You can't give me Canner. You've got to give me the whole darn site. So there it is. It is important to recognize that a skilled nursing facility is essentially where someone is currently residing, oftentimes for the rest of their lives, usually for many, many months and years. Intermediate care facilities, generally speaking, are where people who are developmentally disabled may have certain psychiatric conditions that don't require a lot of medical treatment but require a great deal of psychiatric treatment. They also are referred to as intermediate care facilities. For the psychiatric patients, we refer to them as IMDs, and IMDs are locked facilities. So let's talk about California Health and Safety Code section 1418.8. 1418.8 is a new statute, 1992. It was drafted and passed the legislature to give SNFs and intermediate care facilities a means of making decisions for incapacitated residents who have no one with legal authority to make healthcare decisions on their behalf. Now, these decisions are never going to be about emergent treatment or acute care decisions. The courts have made that very clear. The legislative history of the statute makes that very clear. These are the kinds of decisions that the people who work in and operate the SNFs and the intermediate facilities have to make every day. Well, what kind of medication? We have the prescription, but can we go with generic instead? Do we have to use a particular kind of drug? There are doctors that come in and tend to the patients. They have made certain recommendations. People who are operating the SNF may decide we need a different kind of wheelchair. We want to give the medication at different times. We would like to do something different with the day-to-day, ongoing, non-emergent, non-acute care for the resident. And this statute talks about residents. It doesn't mention patients a lot. So that was the reason that this statute was enacted. So, okay, along comes the Canner decision. Canner, remember what that means. California Advocates for Nursing Home Reform. These are very alert, involved, and aware advocates for people who are residents of nursing homes and some other nursing home type facilities. They filed a lawsuit that said, hey, this statute's unconstitutional. There was a taxpayer. There's always a taxpayer who complained, not only is it unconstitutional, you're spending way too much of our taxpayer money worrying about these folks in a nursing home. I will spare you the legal weeds that the appellate court went through. The Superior Court, which is the court that I sit on, the Superior Court disagreed with Canner and said, no, the statute's fine, it's constitutional, we are going to deny your claim. Canner appealed it to the appellate court. The appellate court took a look at the statute, and what's very, very interesting in the appellate case, rather than finding that the statute was unconstitutional, the appellate court recognized the great need for this statute and cleaned it up and sent it back to the trial court and said, okay, we want you to make the findings that we've sent along to you. And when you make those findings, Judge, guess what? You're also going to be able to find that the statute's constitutional. Appellate courts don't do this very often. This was really a rather rare exercise on the appellate court's part to have this statute meet the constitutional standard so that it could also meet the underlying needs of the people for whom the statute was initially enacted. So before we look at what the appellate court did, I want you to know who this case was about. Give me 1 second. I want to talk to you about Gloria A. We never use persons' last names when we're talking about privacy rights. Gloria was a 63-year-old truck driver who ended up in a nursing home. Upon admission, the admitting physician noted in the record, "I'm declaring her incapacitated." 3 weeks later, another doctor examined Gloria and wrote in the record, quote, "This resident has the capacity to understand and make decisions." Several months later, Gloria decided she wanted to go on a picnic with one of her fellow residents and friends. That resident's sister had shown up, and they had looked forward to this outing for days. They got all dressed up, got their picnic gear ready to go, got to the front door, and one of the administrators of the nursing home ran up, grabbed Gloria's arm and said, "Where are you going?" And she said, "I'm going to a picnic with my friend. Her sister has taken the day to come and take us out. Gorgeous day." And Gloria was told she wasn't going anywhere. She asked why, and she was told, "Because you lack the capacity. We can't let you go with anyone. There's no one responsible for you other than us. You're incapacitated. You're staying here." Gloria was shocked because no one had told her that a doctor at admission found her incapacitated. Nor did anyone tell her that 3 weeks later, another doctor found that she was not incapacitated. There was ultimately a decision made by an IDT at the nursing home that Gloria, not only was she not going to be going out, she needed psychotropic medication. Gloria made it very clear to the social worker that came to visit her, "I don't want to take psychotropic medications. What am I taking this for? No one's told me anything. I don't have a diagnosis, a psychiatric diagnosis." The psychotropic medications were administered in any event against her will, and 4 months later, Gloria died. This is the person that was championed by Canner in this case. And I always think when we're talking about cases, particularly ones that make big changes in the law, always go back to the facts. Familiarize yourself with the human being behind the title and the name of the case. So here's what the appellate court did to save the statute and make it constitutional. The first is notice. Remember way back at the beginning I told you due process requires notice. So the SNF or the physician must provide, and this is interesting, notice both orally and in writing, not just to the patient or resident, but to another competent person whose, quote, interests are aligned with those of the resident. The notice has to include all of this information. The fact that the resident has been found to lack capacity and that they lack a legal surrogate, the proposed treatment, a fact that the IDT will make a decision on the proposed treatment, the right of the resident or patient to have a representative participate on the IDT, and you'll see in a minute, the IDT is now required to have a patient advocate on it who is completely unaffiliated with the SNF. The resident also needs to be advised they have a right to seek judicial review. They must be given a reasonable opportunity to seek the judicial review. So you see in this requirement now, due process is being written into the statute in order to save it. The court also found that 1418.8 may be used to impose or change, I had to look this one up, a POLST, a DNR, comfort care orders, or a decision to provide hospice care to a terminally ill patient. I see many of these petitions asking for hospice care. The one thing the court drew a line in the sand, the 1418.8 process may not be used to make a determination regarding withdrawal of life support. That's a decision that has to come through the court. That's the 3200 petition. The court did allow the 1418.8 process to be used for the administration of antipsychotic medications. That's a huge decision. That is the only decision I know of outside the LPS statutes that allow anyone to make decisions about antipsychotic medications other than a treating physician. I'm running out of time. I'm going to give you a quick synopsis of my decision-making process. When I get these petitions, I read them thoroughly. When I'm done reading them, the first thing I do is check my own personal biases. I change some of the basic facts and the demographics about the patient. I think about the decision I'm about to make. If this were a friend of mine, if this were my 88-year-old father, if this were a colleague, I then reread the petition with that in mind and think to myself, would you be making the same decision? I don't make economic decisions. I don't care how many beds you have filled. I don't care there are 50 people in the ER and you've got no place to put them. That does not play a role in my decision making. I don't care that the person is homeless, has more ailments and diseases than you can squeeze onto your petition. I only care that I have the information that tells me this person needs this treatment in order to sustain life or in order to improve life. I do talk to patients. I talk to several patients a week with regards to the 3,200 petitions. I want to know what they actually have to say. It's not enough for their voice to be heard through the layers of doctors and lawyers in my courtroom. I think very carefully about each one of these decisions. I have never denied a 3,200 petition, but I have limited them. I will allow a colonoscopy and all that goes along with it, but if you find something in the colonoscopy, you've got to come back to me and tell me what kind of surgery or what kind of cancer treatment. I will not give you the entire kitchen sink. I'll give you the faucet. Come back to me for the rest of the sink. With that, I think there may be questions. Dr. Reed, I don't know.
Yes. Thank you so much. This has been fascinating. We do have some forms that are coming in, or some questions that are coming in. What I'm going to do is zoom out here. Zoom out the camera would be helpful if I aimed it actually at the camera itself. And turn the camera, whoops, wrong way.
That's the door out.
Oh, so it was, yeah, sorry. There was. Okay, so here we are in the same frame. This is fantastic. So we have a question here. It seems that in conservators, particularly those who are doing so in a professional capacity, but also those acting pro bono, are reluctant to agree to withdrawing or withholding medical therapies, even when those therapies have been deemed medically ineffective. And the question is, can you comment on any legal standards that might drive better behavior amongst conservatives, as well as whether conservatives should or should not be so reluctant? And honestly, just only because I'm married to a lawyer and I love this whole, talk about equal protection under the law, the inability of a conservator to make a decision that is truly in the best interest of the patient from a medical perspective, wouldn't that be a violation of equal protection under the law?
The quick answer to your last question is yes. So let's talk about this. There are really two different kinds of conservators. The professional conservators, we call them profids, professional fiduciaries, and everybody else usually being family members. Family members have, generally speaking, no problems making these kinds of decisions. The family has usually chosen the person who will make these decisions and knows how to do it. Understand the professional fiduciary is in a very different role. They have an even higher standard of care than a family member who's a conservator, and they are licensed as professional fiduciaries. They are going to be very, very picky, and I'm also going to be really honest. CYA are 3 letters that they think of quite frequently in many of their decision-making processes. I understand why they need to do that. If you're having a difficulty with somebody who is a professional conservator, a professional fiduciary, ask to speak with their attorney. They will all have attorneys. And if you really believe that the patient needs a different treatment, find out who the attorney is that represented the conservatee, or talk to the attorney who represents the professional fiduciary and file a petition in the court. Come to court. Make us aware of what's going on, and we will help make the decision by authorizing the professional fiduciary or the physician to make that particular medical decision.
And yeah. What about the public guardian's office? Is there a special relationship between, that's probably a bad term, but is there a relationship between the public guardian's office and probate court in which the public guardians feel like they have a more broad understanding of their duties, of their fiduciary duties?
Yes. Answer is yes. But again, here's the reality of life on the ground. Our public guardian's office, you will not be shocked to hear this, is so overwhelmingly underfunded, lacks the staff that they need in order to, I think, adequately do all of the things I would like them to be able to do. And so they are very reluctant to take on probate conservatorships. Where I deal with the public guardian is, of course, every LPS conservatorship in this county, save a very few, they are the conservators for everyone that comes out of the LPS system. There are hundreds, if not thousands upon thousands, of LPS conservatees. And so their resources are very much geared to the LPS conservatees, much, much less to probate conservatees.
And here's just a follow-up question on that. Then are there any guidelines that can, either for either population, the LPS or probate conservatees, are there guidelines that may allow the public guardians to agree in certain situations to withdrawal of life-sustaining treatment, for example?
I've had one 3200 petition to withdraw life-sustaining treatment. It was the classic unplug. The 3200 was filed by the public guardian. They ultimately found a daughter for the 57-year-old woman who had had a massive stroke. The daughter was terrified. I made the decision to designate the daughter to make the decision with regards to removal of life-sustaining treatment. The daughter broke down in tears in court and looked at me and said, thank you. She perceived that I was giving her permission to make the decision that the doctors were recommending, and that she ultimately did remove her mom from life support. That is the only petition asking for that I've ever seen. There is no reason that those petitions cannot be filed more regularly. Not that I'm asking for all the extra work, but there really isn't. That doesn't have to come just through the public guardians and the LPS. You really reach out to the courts. You have the power to file petitions to bring some of these issues into a courtroom. You've got a hard enough job. You don't need all of the extraneous persons involved or uninvolved muddying those waters. Come into court. Let us take a look at it. We will not make the decision for you, but we will designate the person who is going to make that decision.
It's very helpful. You know, I just want to be mindful of our time, meaning that if you are willing, Judge Reilly, if you could stay over a little bit longer just for more of a dialogue, we'd appreciate that. But I do want to just turn it back over to Dr. Winslow. We understand that there are those who will not be able to stay over. But Dr. Winslow?
Yes, thank you, Judge Reilly, for a most informative session. And we have taken up a few of the questions that have been sent to us via chat. I think there are a couple of others that would be worth discussing. If people who are on the Zoom meeting want to stay on for just a few minutes, and Your Honor, if you're willing to take a few more questions, perhaps we can go on for another 10 or 15 minutes. I know
I'm happy to stay.
Okay, a number will need to drop out, but and I think, Dr. Wee, you'll see the questions that have been submitted there in the arrangement that we've made.
Very good. So here's another question here, and this relates to Canner. Something that was really interesting for me was to know or recognize that Canner was not meant for acute care decisions, but some more of these chronic care decisions for residents, not patients.
Correct.
And to me, that is so it's very striking because in acute care settings, in acute care hospitals, we don't have a mechanism by which decisions can be made for unrepresented patients. That has been codified in statute, for example. And so I guess there's two questions in this. The first one, does Canner give adequate authorization for an interdisciplinary process to be used in the acute care setting? Well, that's the first question. I'll stop there, and then we'll go to the second question.
This was a rabbit hole that I ran down along with my managing probate attorney for several days. This exact question. And I asked her, I said, would you run a research query for me? Does 1418.8 or Canner come up in any cases regarding acute care hospitals? And the answer comes back, no. So we decided, with our great legal insight, but I think this is probably pretty accurate. I think there are two reasons for that. I think 1418.8 in Canner, there is an implicit recognition that there's a fundamental difference between a nursing home and an acute care hospital. A nurse, I don't need to belabor that point. You all are probably more familiar with those differences than I am. But if you're in a nursing home or one of the intermediate facilities we talked about, and you become ill beyond the already diagnosed, we're taking care of the treatment, we're giving you the medication every day, they don't mess around. They put you in a van or an ambulance or a transport vehicle, and they take you to the acute care hospital. They don't want to be responsible for these kinds of decisions. They need to get you to a place where the people who have the education and the training and the experience and the resources that can care for you. And I would imagine the legislature and some of the patient advocate groups are loath to pass along the IDT decision-making framework to an acute care setting. Let me analogize it for you. A brand new judge taking the bench for the first time, despite the fact that we all think we're very cool and know everything. Your first assignment is in our traffic court. And we may let you also hear small claims and unlawful detainers. Not too many UGs right now. But we want you learning how to be a judge. And we want you making decisions where if you mess the decision up, no one's going to be hurt. It's a traffic ticket. It's a small claims case. Not that they're not important, but it isn't a death penalty case. It's not a complicated family law case where you're trying to decide who's going to get to raise the children and whether mom or dad's ever going to really be able to see them unsupervised. Those are life-altering decisions. We want you with training wheels for a while before we turn you loose on the populace at large. I think if you take that analogy and apply it to skilled nursing facilities and acute care, we're not ready to give up the big decision-making yet to acute care facilities. I'll also be honest with you. I think the Canner group is one well-connected political advocacy group. Notice their name is in the title of the case. They're the ones that brought the case. Acute care facilities, I know you have advocacy groups. I know you have lobbyists, and that's how you're going to get it to the attention of the legislature. You also would need to work very, very closely, hand in glove, if you will, with the patient advocate groups. If both sides got together and drafted something up, that's how you're going to get the attention of the legislature. In the meantime, don't avoid us because you're afraid of us. We do take time. That's almost required because we have to make sure that we are checking and balancing every decision, making sure everyone has notice, the opportunity to be heard. But if you feel you need to bring a petition to court, bring the petition. Worst that's going to happen is we're going to send you away and say, not this time.
So I think it's really interesting where the number of 3,200 petitions that you have heard in order to transition treatment away from aggressive therapy towards maybe life-ending or comfort care, it sounds like you've not really heard a lot of those petitions.
The ones that I hear are, I do get a lot of requests to transfer someone to hospice once they get there to allow a DNR to be placed. I've had several recently to remove feeding and water. I will tell you that I allow hospice quite frequently. I allow the DNR always in a hospice case. I have allowed removal of the feeding. I have never allowed the removal of water. And that is, I'd love to tell you there's some great legal reason. There isn't. It really is more of a sentiment. The person is dying. I recognize that. I can't take the water away from them. I do see those kinds of petitions a lot. I've only had one where it was a pull the plug decision.
I guess the reason why I'm asking those questions together is that just based on my clinical experience, it would seem that not having a mechanism has not allowed, that's not a good word, but these decisions are happening, and they're not happening with the oversight of the courts because of perhaps a lack of petitions that have come before you, but is also not happening with the oversight of and protection of the law either.
And so your point is really well taken. And that's one of the first things that I would ask, if I were in Dr. B's shoes, I would ask an advocacy group to think about. The reality on the ground is, do you think these decisions aren't being made? What, you think all of a sudden people aren't dying in hospitals? help us develop, through the appropriate legislative process, statutes that will allow us to make these kinds of decisions. Frankly, you have everything you need in place in your facilities to make these kinds of decisions, particularly if you develop the IDTs that are talked about in the Canner decision. You can also set up a process for quick court review. The 3,200 petitions in our county, I'd love to tell you, they're belabored, they take forever. They don't. That petition gets handed to me, and within 45 minutes, I'm making decisions. If I need more information, that might be part of the decision. We do everything we can to get the doctor on the phone and in the courtroom via phone that day. I don't want to let those petitions go over. At most, I'll allow them to go over a week or two, and that's only with our state hospital patients. That's a little bit different than what I'm dealing with. We move them along because I know someone is waiting for medical treatment, and it may be critical medical treatment. You can streamline these processes, and when it comes into court, letting us know, dire emergency, judge, this has got to be heard quickly. We'll step it up and we'll hear it quickly.
So I just want to make sure that I'm understanding. We're talking about forming a closer relationship between the courts and what's going on currently in the medical system, because this is one of the ways where patients can have a check on what is going on their healthcare. And
absolutely. And
these are not processes that are currently in place, which may lead to some of us in the medical field being very hesitant to come into court. It's very scary for me to think about, I'm going to have to go to court.
You need to know, I'm as terrified going into a doctor's office as you are probably walking into my courtroom. And we should all remember that. I mean, I think often when people are coming into the courtroom, and I had a little gal a week ago who is just had her first psychotic break. She's 22. Diagnosis is paranoid schizophrenia. She does not have a therapeutic dose on board yet. They opened those courtroom doors. I thought this poor thing was going to jump. And I spent 20 minutes literally repeating, come on in, you're safe here. She finally came in. We had a great conversation. And it's a reminder to me, where I work is terrifying. I mean, I look like the Wizard of Oz. I'm up on this big dais and I'm in this black robe and my voice is booming over microphones in the courtroom. You need to know, when I go into a doctor's waiting room, and first of all, it's freezing cold, and I'm handed a gown that, by the way, is not like any gown I own at home, and either doesn't fit or fits too well. I'm terrified. And I see a lot of doctors here at Loma Linda, all of whom I love, but every time I go to see them, there's still that lump in my throat. This is a doctor's appointment, and I don't have the knowledge or the experience. Our professions, both of them, are terrifying to the people who have to come in and use the courts or see a doctor. So I get it. I really get it. But we've got to overcome that, and we do need to work better with each other. There are some unpleasant things that I would love to sit down with primarily psychiatrists and discuss. There are people that are being released under the law. The law should be rewritten, I think, humbly, my opinion, about psychotropic medication and how long we can hold you and get you stable before we say, bye-bye, here's a prescription, and oh, by the way, here's a referral. The meds get dumped in the trash can outside the door of ARMC along with the referral. We will see this person back in the hospital within 72 hours. We're not doing a good job for the mentally ill of our communities. The legislation needs to be changed. The way we operate our facilities needs to be changed. But we're afraid to have these conversations with each other because it requires that we acknowledge practices both by the law and the medical profession, that maybe they're not best practices anymore. When Lanham and Petra Short was enacted, it was a sea change in how we dealt with the mentally ill. But that was back in the 1970s. Things have changed. Medications have improved. We have not changed our practices. The law is exactly the same. I'm allowed to hold somebody for 72 hours without a lot of falderall. I can hold them longer than that, but it requires a lot of hearing. When we all know those meds need 4 to 6 weeks on board before they're really going to begin to clear the mind and stabilize the patient. And every day I sit there and I make these orders and I think, dear God, can I hang on to this person long enough that I know we can get enough medication in you that we can now work with you?
You know, I, again, want to thank you so much for coming in. I think you make such a compelling argument, again, just for our professions to work together and to understand that we are, you know, as I take it, the legal system is not a threat to the medical system. It's there to protect patients, to protect clinicians too, and also to enable clinicians to do what they feel like needs to be done in the best interest of the patients. And I look forward to continuing this conversation. I want to thank our viewers who have hung on to us, hung on through this conversation. We really appreciate you being here. And Dr. Winslow, do you want to just give a quick promo about our next event? And then
Yes, let me just mention that we have Dr. Sunita Puri from the University of Southern California coming to speak to us in November. If you'd like to be added to our distribution list, and you are not currently, just email us, bioethics@llu.edu. Again, bioethics@llu.edu will add you to the distribution list, and you too will be invited. So let me add my personal word of gratitude to you, Judge Reilly. This has been highly informative, and I'm sure that it will lead to subsequent conversations that I think will be fruitful. So thank you very much for your time today.
Thank you for the opportunity to speak. I deeply appreciate it.
All right, thanks to all of you. We'll end the meeting now. Goodbye.